Imagine waking up to find yourself detained by the police without a single explanation. Or picture a government department suddenly refusing to process your perfectly valid business license, freezing your livelihood overnight. When you're up against the massive machinery of the state, the default assumption is that fighting back means years of exhausting bureaucracy, endless paperwork, and a legal process that outlasts your savings. But the architects of the Indian Constitution built in a direct override. It is called a writ petition. Instead of crawling through the lower courts, a writ petition allows an ordinary citizen to take a violation of their legal rights straight to the highest courts in the country. A writ is an active judicial command. It forces immediate intervention from the judiciary to stop government overreach in its tracks and hold public authorities strictly accountable to the written law. Before drafting a single document, a petitioner faces a critical strategic choice. The Constitution offers two distinct pathways for filing a writ, and choosing the right one dictates exactly where your case begins. The first is Article 32. This provision grants you direct access to the Supreme Court of India, but there is a strict limitation. The Supreme Court will only hear a writ under Article 32 if the case involves a direct violation of a fundamental right, like the right to life or equality. This brings us to the second pathway, Article 226. As this diagram illustrates, Article 226 actually gives the high courts a much wider jurisdiction. While the Supreme Court's power under Article 32 is strictly limited to fundamental rights, the high courts can issue writs for both fundamental rights and ordinary legal rights, such as a breach of a statutory contract by a state body. If you attempt to take an ordinary legal dispute straight to the Supreme Court under Article 32, the petition will be dismissed. Knowing the exact boundaries of these two articles is the mandatory first step to securing relief. Once you are in the right court, you have to request the correct type of remedy. The Constitution provides 5 specific types of writs, each engineered to fix a different category of state failure. The most immediate of these is habeas corpus, which translates to produce the body. This is the ultimate legal shield against unlawful detention. If the police arrest someone without lawful authority, a judge will use this writ to command the police to bring the detained person physically into the courtroom. If the state cannot legally justify the arrest on the spot, the person is released immediately. The next writ is Mandamus, meaning lee command. You use this when a government official or public body completely fails or refuses to do a job the law requires them to do. Look at this workflow. If a local municipality refuses to issue a valid building permit, stalling the entire process, Mandamus breaks the gridlock. The court issues a direct, non-negotiable order compelling the department to discharge its legal duty. Habeas corpus and Mandamus are active interventions. They compel the state to take physical action, whether that means unlocking a jail cell or processing a document, to restore your baseline rights. But the threat to your rights doesn't only come from the police or bureaucrats. Often, the danger comes from lower courts, tribunals, or quasi-judicial bodies that try to rule on matters outside their legal jurisdiction. The High Court uses a writ of prohibition as a preventative strike. If a lower tribunal oversteps its authority, a barrier drops, halting the trial. If the illegal order is already issued, the court uses certiorari, a curative strike that completely quashes the invalid decision. The final writ is quo warranto, or by what authority. This empowers any citizen to challenge a person sitting in a public office if they do not meet the statutory qualifications for the job, forcing them to prove their legal right to hold that position. By deploying prohibition, certiorari, and quo warranto, the higher courts act as quality control for the justice system itself, ensuring that lower officials and judges operate strictly within the law. These 5 writs offer extraordinary access to justice, but they are not a blank check. Courts actively guard against their misuse, meaning you cannot use a writ petition as your first resort if you have other reasonable ways to solve the problem. This diagram shows how courts filter these petitions. If your case involves highly disputed facts that require detailed witness testimony, or if you wait too long to file, your petition is filtered out. Most importantly, if there is already an effective alternative remedy available through a standard statutory process, the court will likely reject the writ. The importance of these limitations and the power of the writs themselves is deeply tied to Indian history. During the 1970s, specifically during the emergency period, executive power expanded drastically. The battle over writ jurisdiction, especially habeas corpus, became the central fight for Indian democracy. Following that era, landmark Supreme Court decisions like Maneka Gandhi in 1978 and L. Chandrakumar in 1997 firmly established that the power of judicial review through these writs is part of the Constitution's basic structure. The government cannot simply amend it away. Because these tools exist, the state cannot act in a vacuum. A simple petition ensures that every public official, from a local clerk to the highest minister, remains accountable to the rules of the Republic. That having constitutional rights only matters if you know the exact mechanisms required to enforce them. If you want to understand more of the strategies and legal levers that protect your freedoms, hit the like button, subscribe to the channel, and we'll see you in the next breakdown.